I am attorney Maricris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, we shall aim to simplify the law. We shall explain concepts and principles of law in under 10 minutes. In this video, let us talk about transmissibility of rights. Some of my clients ask me if they will inherit the debt of their parents, while other clients would also ask me if they can still collect from the debtors of their parents. The answer is yes. So why do we say that we can still inherit the debt of our parents after their death? And why do we also say that we can still collect from the debtors of our parents after their death? The answer to that is Article 1178 of your Civil Code, which speaks of the transmissibility of rights. Article 1178 says, subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. From that provision itself, it tells you that the general rule is rights are transmissible. Meaning to say, if X and Y are parents of A, and X and Y has a debt with a bank, X and Y after their death will now be transferring that obligation to A, their child. In the same manner, the bank can still collect from A. There is, however, a limitation to inheriting debts. The limitation is that you can only be asked to pay to the extent that you have inherited from your parents. In other words, if X and Y is indebted to the bank in the amount of 10 million, but the properties they have left with A after their death is only 8 million, then A is only liable to the extent of 8 million that he has inherited from X and Y, his parents. Now, let's look at the other side of an obligation, the side of the creditor. If the creditor dies and is survived by an heir, let's say X is a creditor of Y and X is survived by A, can A still collect the debt of X from Y? The answer is yes, because 1178 says that rights that are derived from an obligation is transmissible. So, in that case, your A can collect from Y, even if it was actually X who is the creditor of Y. So that is your general rule, that rights are transmissible. Of course, there will always be exceptions to your general rule. And what are the exceptions? So what are the exceptions? The first exception is when the right, by its very nature, is not transmissible, as in a purely personal right, like your right to vote. So of course, that cannot be transmitted. The second is when the parties agree and stipulate in their agreement or contract that it will not be transmissible. Another exception is when the law says that it is not transmissible. So that ends our very simple discussion on the transmissibility of rights and the exceptions to such. If you have learned anything from this video, please feel free to click like and subscribe. If there is any other principle or concept of law which you would want me to discuss in this channel, please put them in the comments section below. Thank you for watching. See you next time in MBL Classroom.